Assalamualaikum and hi, my name is Mohd bin Zamrain and my magic card number is DIL2236. So today I will be presenting my part, which is introduction under topic product quality and safety under criminal law. So we'll start with introduction. For the purpose of ensuring the safety of product and services in Malaysia, standards are implemented as the bare minimum requirements. In order to reduce costs, Standard Malaysia has contracted Shri, a corporate standard development agency, to handle the majority of national standards development activities. A product testing and certification agency, Shri, through its subsidiary Shrimcast International Sdn Bhd, which supports the promotion of Malaysian and international standards for various industries, is operated by Shri. Consumers in Malaysia are concerned about their safety for a variety of reasons, particularly because they are exposed to a wide range of hazardous chemicals at varying levels and for varying periods of time in a variety of consumer products, including food, drugs, cosmetic, household chemicals such as insects or aerosol sprays, detergents, pesticides, building and constructions, materials and structures, perfumery, air fresheners, household paints and varnishes, and motor vehicle safety features, part maintenance, and and lots more. Section 66 defines product as any good or service, and it includes a product that is included in another product by virtue of being component part, raw material, or other means. Section 67 of the Code of Civil Procedure 4, safety in relation to a product shall include A. Safety with respect to the products contained therein, B. Safety in the context of the risk of property damage, and C. Safety in the context of the risk of death or personal injury as defined in these sections. The next part, which is definition. The Malaysian Parliament has recently passed the Consumer Protection 1999, hereinafter referred to as the Act, with the aim of providing better legal protection to consumers. The Act covers most major areas of consumer protection, including product liability, which is contained in Part 10 of the Act. Product liability is generally understood as referring to the civil liability of a manufacturer or distributor for damage caused by a defect in a product. Under the existing law, the victim of a defective product has to seek remedy either under the law of contract or tort of negligence, which obviously is inadequate to protect them. The Act basically introduced a new system of liability in respect of death, personal injury, and damage to property caused by defective product. Such a system is believed to overcome the problems inherent in contractual and negligence remedies and accordingly give better protection to the consumers. However, as most of the provisions on product liability are based on Part 1 of the United Kingdom Consumer Protection Act 1987, the criticisms of the UK Act may equally apply to the new Act. This article aims to provide an overview of product liability law in Malaysia under the Act, the Kingdom Consumer Protection Act 1987. The criticisms of the UK Act may equally apply to the new Act. This article aims to provide an overview of product liability law in Malaysia under the Act. All the important provisions of the Act will be considered in order to provide a fuller appreciation of the scope of protection offered, its adequacy, and its weaknesses.
Assalamualaikum and hi everyone, my name is Putri Shazlin Mohamad Shairulkamar, DIL193036. I'm gonna present about elements of product quality and safety under civil law and criminal law. For the product's quality, Section 16 of the Sale of Goods Act provide for an implied condition in the contract of sale that the goods shall be marketable quality. Violation of express or implied terms give the right to treat the contract as rejected. Violation of the warranty give a right to claim the damages but not the right to reject the goods and treats the contract as rejected. The qualities of the goods are refers to its condition. This implied condition on negotiable quality applies even if the goods are sold under the patent or trade name. The goods must be reasonable to fit the purpose for which the buyer desires them. The common rule of law is let the buyer beware. For example, the buyer must be careful when he makes a purchase, otherwise he must bear the consequences. This regulation is restated in Section 16 of the Sale of Goods 1957. The two exceptions for this rule are the goods must be reasonable to fit purpose for which the buyer wants them, and the good must be merchantable quality. As in the case of suitability for purpose, the implied condition that the goods must be tradable quality applies only where the sale is through a description from the dealer for such goods. There are the dimensions of quality. Firstly is features. The same approach can be applied to product features. Features are the best and weakest of products, those secondary characteristics that supplement the product's basic functioning. For examples, include the free drinks on a plane flight. Secondly, the perceived quality. The perception of quality can be as subjective as assessment of aesthetics. Lastly, the serviceability. The serviceability is same as a speed or efficiency of repair. Consumers are not only concerned about the defective products but also about the time elapsed before service are restored, the timeliness of safe service appointments, the nature of their dealings with service personnel, and the frequency of service call and failed repairs. Next is product safety. Product safety is the ability of a product to be safe for its intended use as determined when evaluated based on the set of established rules. The legislation set out clear testing and documentary requirements that must be complied with the manufacturers and distributors placing equipment on the European market to demonstrate that their product meet established safety criteria and safe for their intended use. According to the Section 20 of Consumer Protection Act 1999 provides that no person shall supply or offer or advertise to supply any goods which do not comply with the safety standards specified under Section 19 subsection 1 of the same Act, in circumstances where no safety standard has been specified. Section 19 subsection 4 provides that the person supplying or offering to supply the goods shall adopt and comply with the reasonable safety standard expected by the reasonable consumer, accordingly necessary of the nature of the good concerned. In Section 21, impose general safety requirement for goods. It provides that, in addition to and without prejudice to Section 20, no person shall supply or offer to or advertise for the supply for any goods which are not reasonably safe, having regard to all circumstances including the manner in which and for what purpose the goods will be marketed, portionment of goods, the use of any marks in relation to the goods, and instruction of warning regarding the storage use of goods. Next, for the penalty, it provides that district forum, the state of commission, national commission, as the case may be, satisfied that the circumstances of any case require impose imprisonment or fine or both for longer period. The minimum period and an amount less than the minimum amount specified in this section. Section 25 of Consumer Protection Act provides that any person who conveys Part 2 and 3 commit an offence. A. If the person is a body corporate, to fine not exceeding 2,500,000, and for 1 second subsequent offences, fine not exceeding 500,000. And for B, if the person is not a body corporate, to fine not exceeding 100,000 or to imprisonment for term not exceeding 3 years or both. For a second or subsequent offence, to a fine not exceeding 2,500,000 ringgit, to imprisonment for a term not exceeding 6 years or both. And the last one is defense upon innocence. The supplier, manufacturer, seller may defend himself as prescribed under Section 27 of Consumer Protection Act. State that whereas in any proceeding for an offence under Section 25, it shall be defense of the accused person to prove that he is guilty, reasonable error on his part, reasonable reliance on information supplied to it, the act or omission of others, accident, and the reason beyond his control. He take reasonable precaution and exercise all reasonable efforts to prevent the breach by himself or by any person under his control. That's all from me. Thank you.
Assalamualaikum, Madam. My name is Natasha, DIL2236. I'll be presenting on case law for product safety standards. In the case of Gardem and Splendid Enterprise, the company supplied to a wholesaler a quantity of the night dresses bearing a label with the reassuring text, "Style to reduce fire danger." The message on the label was false. To accord with the relevant statutory standard, what the clothes should have carried was a warning in the following terms, such as warning, high free danger, keep away from the fire. The standard contravene in this case was introduced to reduce the risk and severity of burns suffered by children in such accidents, and by appropriate labeling to make parents more conscious of the relative risk of different categories of garment. In the case of David Chilia and A. Colville Pillai, Chila David, and against Monorail Malaysia Technologies, Remberhad, and others. In this case, the plaintiff was standing at a road divider directly below an elevated monorail. Train was passing by on a test run. As it passed, a safety wheel from the train weighing around 30.4 kilogram came off and fell on the plaintiff below, causing him to suffer serious head and bodily injuries. The plaintiff then brought an action against various parties for negligence, including the first defendant, who was a designer and manufacturer of the monorail train, and the second defendant, who was responsible for the installation, commission and operation of the monorail system. From the result of this investigation that were conducted, it appeared that the bolts from the wheel could have been unscrewed gradually and were eventually detached from the hub, causing the wheel to come off. Therefore, Harminder Singh, GC, which is the judge, held that logically the possibilities were that this could happen if the bolts that had not been tightened properly, but the reason in charge, or if the bolts had been tampered with by someone else. Moving on to the second case for defect. In the case of Puncak Niaga, Sdn Bhd against Anzac Wheels, 2012 and 27, the plaintiff took delivery of a brand new luxury Mercedes motor vehicle in April 2006. The car could not start on 7 separate occasions. The plaintiff then decided to return the car on May 2007. The court decided that the car was not in fact and in law of an acceptable quality. The defect was substantial, which entitled the plaintiff to reject the car. From this case, a company can be consumer and gets protection under the CPA, which is the Consumer Protection Act. The substantial defect might either exist, a latent defect at the time of purchase, or it might result because of an accumulation of more minor defects which in themselves could not be described as substantial. Another case for defect is, according to Honda Malaysia, the company announced a recall involving 23,476 units of Honda vehicles that were previously recalled to replace the Takata front airbag inflators as a preventive measure. The company apologized for the inconvenience caused to customers once again, as customer safety is always the company's top priority. The company believes this replacement is necessary as a precautionary action and urged affected customers to replace the defective Takata front airbag inflators as soon as possible. The replacement of the defective Takata front airbag inflators is free of charge, and cost of the replacement will be borne from the company. The affected customers will receive notifications letter from the company with the details of this recall and stock availability. The company strongly encourage customers who receive this letter to send their vehicles to any of the 95 Honda authorized service dealers for inspection and replacement. The replacement of Takata front airbag inflator stock for these 23,476 units of Honda vehicles will be available in stages. For product quality, in the case of Puncak Niaga Sdn Bhd against NZ Wheels Sdn Bhd, where a new luxury car known as Mercedes-Benz kept breaking down, the court held that the car was not of satisfactory or acceptable quality and was unfit for its purpose. When the Benz car could not start, there was a breach of implied condition or guarantees which rendered the Benz car not to be of satisfactory or acceptable quality and unfit for its purpose. Another case for manufacturer's liability under Part X is in the case of A and others against National Blood Authority and others, 2002. The court held that contaminated blood with the hepatitis C virus was defective because the public at large were entitled to expect that the blood transfused to them would be safe. Burton J held that the issue of safety should be judged not based on actual expectation of the public but on the entitlement to expectation, and this is a matter to be decided by the court, which was illustrated in the case of Winterbottom against Wright. The plaintiff, Mr. Winterbottom, was contracted by Postmaster to drive the mail coach. On the other hand, Mr. Rick, the defendant, was contracted by Postmaster to maintain the coach in a safe state. However, the coach collapsed and Mr. Winterbottom was injured due to the incident. Mr. Winterbottom sued Mr. Reed for the injury. The court then held that the plaintiff has no redress as he has no privity to the contract. The contract to maintain the safety of the coach is between the Postmaster and Mr. Reed. There were the parties privy to the contract, and there are the parties who can sue and be sued under the contract. Moving on to the next one, which is law. The law that is used in this subject, in this topic, is Section 66 of Consumer Protection Act 1999. Product means any goods and includes a product which is comprised in another product, whether by virtue of being a component part, raw material, or otherwise. Section 67, subsection 4, for the purposes of this section, safety in a relationship to be product shall include safety with respect to products comprised therein, safety in the context of risks of damage to property, and safety in the context of risk of death or personal injury. Section 16 of the SOGA 1957 stated that buyer must exercise care when he makes purchases. If he does not, he must bear the consequences. Section 19 on the safety standard, the Minister of Ministry of Domestic Trade, Cooperative and Consumerism may prescribe the safety standard for goods and services. This standard is not applied to healthcare, goods and food. Section 20 of CPA provide that no person shall supply or offer to or advertise for supply any goods which do not comply with the safety standards determined under Section 19, subsection 1. The next one is Section 19, subsection 4 of the CPA provides that the person supplies or offer to supply the goods shall adopt and observe a reasonable standard of safety to be expected by a reasonable consumer, due regard being had to the nature of the goods concerned. Section 21 of CPA imposes general safety requirement for goods. Section 20 stated that no person shall supply or offer to or advertise for supply any goods which are not reasonably safe, having regard to all the circumstances, including the manner in which the purpose for which the goods are being or will be marketed, the get up of the goods, the use of any mark in relation to the goods, and the instruction or warnings in respect of the keeping, use or consumption of the goods. Section 25 of CPA provides that any person who contravenes Part 2 and 3 commits an offence. If such person is a body corporate, to a fine not exceeding 250,000, and for a second or subsequent offence, to a fine not exceeding 500,000. If such person is not a body corporate, to a fine not exceeding 100,000, or to imprisonment for a term not exceeding 3 years, or to both. And for a second or subsequent offence, to a fine not exceeding 250,000, or to imprisonment for a term not exceeding 6 years, or to both. However, the supplier, manufacturer, seller may defend himself as stipulated under Section 27 of the CPA 1999, whereas in any proceedings for an offence under Section 25 of the CPA shall be a defence for the person charged to prove that his guilty was due to a reasonable mistake on his part, reasonable reliance on information supplied to him, the act or default of another person, an accident or a cause beyond his control, and that he took reasonable precautions and exercised all due diligence to avoid such contravention by himself or by any person under his control. Section 68, subsection 1 stated that where any damage is caused wholly or partly by a defect in a product, the following persons shall be liable for the damage. Section 66 defines product and cover on goods and component parts and raw materials. Section 67, subsection 1 define defect as there is defect in a product if the safety of the product is not such as a person is generally entitled to expect. Section 67, subsection 2 further states that in determining consumers' expectation, all relevant circumstances shall be taken into account, including the manner in which and the purposes for which the product has been marketed, the get up of the product, the use of any mark in relation to the product, instructions for or warning with respect to doing or refraining from doing anything with or in relation to the product, what may reasonably be expected to be done with or in relation to the product, and the time when the product was supplied by its producer to another person. Last but not least, Section 107, subsection 1 of the CPA 1999 stated that the TCC can assist the parties to negotiate an agreed settlement in relation to the claims. Where the parties have reached an agreed settlement, the TTC shall approve and record the settlement, and the settlement shall then take effect as if it is an award of the TCC, according to Section 107, Subsection 3 of the CPA 1999. That's all from me. Thank you.
Hi, my name is Shri. My metric number is DIL193047. My part is the example of the products. There are various consumer products such as traditional medicines and health supplements, foods, cosmetics, detergents, and etc. The traditional medicines and health supplements that use materials of natural origin such as plants and animals are likely to cause contamination, deterioration, and variation in quality. Consequently, the control of the starting material, storage, and processing of traditional medicines and health supplements is important. The manufacture of traditional medicines and health supplements depends on the starting materials, manufacturing process, building equipment, and peoples involved. Good manufacture of Good manufacturing practice, also known as GMP for traditional medicines and health supplements, is part of quality assurance, which makes sure that products are steadily produced and control the quality standard of the products appropriately. GMP also identifies the important principle of food hygiene and safety applicable within food processing to certify that food is processed under a clean environment and the quality is suitable for human consumption. The Ministry of Health section of Food Safety and Quality Division, which aims to increase the level of standards of domestic food manufacturers in producing safer food, cosmetics, and health supplements and traditional medicines. Under the control of drugs and cosmetic regulations, 1984 manufacturers need to ensure agreement with the Asian Guidelines on Good Manufacturing Practice (GMP) for cosmetic. Product safety is an important part for every part to safeguard from harmful things occurring to the consumers. The consumer's protection safeguards in Malaysia are not only emphasized before a product being noticed but also refer the sale of the product and the effect that will be received by the consumer upon using the product. Thank you.
Assalamualaikum and hi Madam Fatiha, I'm Nadhira binti Zaidin, DIL 193046. Now, I will jump to the conclusion. To sum up, although the goal of introducing a strict civil liability system for product responsibility under Part 10 of the Consumer Protection Act 1999 is to decrease the burden on consumers under the law of negligence, it does not fulfill its purpose and does not deliver justice to the customers. The preceding explanation indicates that the aspects of products liability are difficult for consumers to prove and are costly. The ingredients are very similar to those found in negligence. The only thing that will relieve consumers is that they will not have to prove their producer's fault. Even if consumers can overcome the difficulties posed by product liability aspects, this does not guarantee that they will be successful in their claims due to the defenses available to the producers. Consumers suffer more as a result of the defenses than producers. In the end, consumers will gain nothing. Product safety regulation in Malaysia govern offences that endanger the public's health and safety. Product safety laws serve a number of critical functions. Some of these goals include developing a uniform safety standard for consumer products, protecting the general public from consumer products that pose an unreasonable danger or risk of harm to consumers who buy and use such products, reducing the number of state and local product safety regulations, making it easier for the average consumer to assess and evaluate the risk of a consumer product on their own, and encouraging companies to adopt and implement safety standards. The application of criminal law is seen to be one technique for controlling product safety offenses. So that's all from me and my group. Thank you and Assalamualaikum.